Welcome back. So let's talk numbers. How many persons are supposed to be in the House of Representatives or the Senate or the Supreme Court? Well, if we look at the written Constitution, we say 2 senators for each state. That's pretty cut and dried. But if we look at the written Constitution, it doesn't really specify how big the Supreme Court should be or how big the House of Representatives should be. At least there's a very wide range for the House of Representatives. That the text says you have to have 1 representative for each state. So that means you could have as few as 50. Or, and the text also sets a limit, but that limit actually, it would given today's population, you could have 5,000. And yet, actually, we don't have a House of Representatives of 50. That's kind of unimaginable. And we don't have a House of Representatives of 5,000. I think that's also unimaginable. And the unwritten Constitution actually narrows considerably the range that the written Constitution permits. I think the unwritten Constitution really says, gee, the House of Representatives, that's supposed to be the people's branch. It's supposed to be closer to the people. It's supposed to be the most numerous branch of the Congress. And so it would be pretty weird to have fewer representatives than senators. You got to have 2 senators from each state on average. You got to have two senators from each state in total, so 100. So it would be very weird to have a House of Representatives that were ever smaller than the Senate. So from the very beginning, actually, the House of Representatives, after the first sentence, was bigger than it had to be because, actually, the critics of the Constitution worried that the House was too small, it was going to be unrepresentative, only a few great men with great reputations were going to get elected. And so, actually, the Federalists promised, even during the ratification process, don't worry, we're going to actually make the House of Representatives as big as the text allows. We're going to basically, as soon as the first census occurs, we're going to have a House of 100 members. The original House, until that first census, was 65 members. But the framers of the Constitution, the Federalists, said, don't worry, when we have a census, we'll pump it up to 100, and we'll keep increasing it until it gets to somewhere around 200, and only then will we begin to think about leveling off or something. And they were true to their word. That promise that they made in the ratification process was part of an unwritten Constitution. The promise was that the House of Representatives would start out after the first census at 100 and keep growing at a substantial clip, and it did. And there's some structural reasons why that makes sense. Once the House is a certain number, let's say 150, it's not going to be, and there's a new census, and census happens every 10 years, it's not going to be in the interest of most House members to try to shrink it down, because that would mean some of them are kind of guaranteed to not be in the next House. So it kind of functions as a ratchet. It hasn't really ever dramatically decreased in size. I think there was one period where it dipped a little bit, but basically it increased until it got pretty big, 435, and at that point, basically, early in the 20th century, I think the thought was, gee, it can't keep growing infinitely, so maybe this is sort of a good size, and so by statute, not by constitutional provision, but by statute, the House is 435. So way bigger than the 50 that would be permissible, way smaller than the 5,000 would be permissible. But you can see how the system itself creates kind of certain incentives for Congress people to listen to constituents. Constituents wanted something bigger than 1 representative per state, but you don't want it so big that they can't even talk to each other and deliberate. So that's the House. Remember, the Senate's easy, the text is clear, 2 senators per state. What about the judiciary? Well, we now have 9 people on the Supreme Court, but we've had as few as 5. At the founding, it was 6. It went down to 5 at one point. It's gone up to as many as 10. And so that's not fixed by the text of the Constitution. Our tradition has been 9 ever since for the 20th century, throughout the 20th century. Franklin Roosevelt very famously tried to change the number in his court packing plan in 1937. He wanted to increase the number to 15, and his critic says, you just want to do that because you're not winning among the 9 who are there, and so you're just trying to pack the court to get a bunch of new justices who will agree with your position. So Congress actually rejected Roosevelt's plan, But the rejection of that plan did not create some unwritten constitutional principle that it has to be 9, because the text pretty clearly says Congress gets to decide the size. And Congress hasn't chosen to exercise that power, but mere non-use of a power doesn't mean that somehow the text is amended. The text still gives Congress this power. It hasn't used it in the last 70 years, but it perhaps could in the future. Just like there were periods of time where Congress never passed a civil rights law, large, half a century, but it didn't thereby lose its power to pass a later civil rights law or voting rights law. So where the text is pretty clear, and I think on the Supreme Court the text is pretty clear, that Congress actually does get to, by statute, determine the size, and it has done that over time. Remember, as few as 5, as many as 10. Maybe it has to change the size for a kind of a good government reason, perhaps, rather than for some mere partisan advantage. Maybe not. That's kind of a debatable realm. What reasons might Congress have for changing or modifying or manipulating the size of the court? But I think there's pretty widespread agreement that if Congress had a good government reason for modifying the size of the Supreme Court, it could do so, because the written Constitution is pretty clear, and the unwritten Constitution merely says it hasn't done so recently, but it did earlier in American history. Okay, so how about the internal voting rules within the House, the Senate, the judiciary? Government entities, we've been talking about how government is constituted, how these organs of power actually operate. That's the kind of constitutional law we're examining right now, how the government is constituted. Some government entity, it can't do anything at all without kind of certain voting rules determining what counts as a decision for or against a certain proposition. And here's the kick in the head. The Constitution doesn't explicitly specify these internal voting rules. They're often implicit. They're part of an unwritten Constitution. So the Supreme Court's now 9. Where does it say that if it's 5-4, the 5 win? Doesn't say so in so many words, but that's been clear from the beginning, that majority rule was just presupposed. And the House of Representatives has always used majority rule, and actually the Senate did early on, and that's because the framers believed that majority rule was just the basic baseline and premise of a system. It's the natural law of every assembly unless it's otherwise specified, said Jefferson, said Franklin, thought all the founders. And so you might say, wait a minute, Professor, what about this filibuster thing that I've heard about? So let's actually talk about the filibuster. Let's use actually the framework we've developed to think about the filibuster, because there are some folks today that think that the Senate actually can't do anything unless 60 senators out of 100 say so. And that the Senate can't even change that filibuster rule unless 60 or more senators vote to change the filibuster rule. The kind of a catch-22, actually, that it requires 60 votes to pass all sorts of bills according to a certain Senate Rule 22, and according to some, we can't really change Senate Rule 22 without a 60-vote supermajority, and if so, Rule 22 would be catch-22 and in tension with the deep majority rule principles that every other institution abides by. So let's take a step back and look at Senate Rule 22, the filibuster rule, using the framework we've been developing. So let's first think about the implicit Constitution. Now, the Constitution says pretty clearly that when a president vetoes a bill, 2/3 of the House and 2/3 of the Senate suffice to override the veto. So obviously, something less than 2/3 should be required to pass an ordinary bill, and by tradition and principle, I'll give you some more reasons, that something less is simple majority rule. Well, let me put it another way. If Senate Rule 22 can entrench a 60-vote rule, why couldn't it entrench a 70-vote rule or an 80-vote rule? But those rules would clearly be inconsistent with the clear text of the veto clause that says 2/3 is enough to override. You can't have an entrenched 70 vote rule. You can't have an entrenched 80 vote rule. And maybe actually now the idea is you can't have any entrenched rule other than majority rule. The Constitution presupposes majority rule. So the reason that a constitutional amendment requires 2/3 is that constitutional amendments should be harder than ordinary statutes. The reason that the Constitution specifies a supermajority rule to expel a member of Congress is the baseline is majority rule. Wherever all these specific voting rules in the Constitution exist against an implicit baseline where nothing is specified, majority rule is the premise. Now, let's look at America's enacted Constitution. Remember, how does the Constitution come about? By state ratifying conventions. How did those state ratifying conventions vote for the Constitution? By simple majority rule. In New York, it was 30-27. And everyone understood when that vote was taken that 30 beat the 27, and everyone understood that even though the text doesn't say that at all. You won't find that in Article 7. You won't find that in the preamble, but everyone understood that majority rule is the basic rule of all branches of government, unless there's something specified to the contrary. Okay, so remember early chapters, we looked at implicit Constitution, Chapter 1, the enacted Constitution, Chapter 2. America's lived Constitution, how ordinary people live their lives. Well, you're members of all sorts of clubs, and ordinarily in clubs and stamp clubs and chess clubs and PTAs and all the rest, unless you have your bylaws specify otherwise, majority rule is the basic principle. Now, what about America's doctrinal Constitution? What does case law say? Actually, case law says majority rule. A very important Supreme Court case called United States versus Ballin proclaimed, this is a quote, "The general rule of all parliamentary bodies is that where a quorum is present, the act of the majority of the quorum is the act of the body. This has been the rule for all time, except so far as in any given case the terms of the organic act under which the body is assembled have prescribed specific limitations. No such limitation is found in the federal Constitution, and therefore the general law of such bodies obtains. Unless the Constitution specifies otherwise, it's majority rule," says the Supreme Court. America's symbolic Constitution, well, some of our greatest icons of America, like the Voting Rights Act, you know, they were passed really despite the filibuster. The filibuster was actually used against some of these things. Now, remember, we've been talking about America's institutional Constitution, and here's where history comes in. The first Senate acted by majority rule. The very first Senate. Remember, they have a kind of a jump-starting question, a little bit like what happened in Congress in the 1860s during the Civil War. By what rule is the first Senate going to organize itself and pass rules of procedure? You know, by what rule is it going to decide what the rules of procedure are? And it decided by majority rule. And what's true for the first Senate is true for all other Senates. And in fact, prior to the Civil War, there was no important measure where a minority actually ever sort of thwarted a majority from expressing its will. No example of anything like today's filibuster for the entire period before the Civil War. And you know this, actually. You may not know you know it, but you do, because you took American history in high school, and you remember, for example, the Compromise of 1850 and what a big deal that was. And it was a big deal because California came in to the Union as a free state without an offsetting slave state, and now for the first time the free states had just a bare simple majority in the Senate, and that was a big deal precisely because bare majorities actually governed in the Senate for the entire antebellum period. Or I can put it another way, if there's some example of the filibuster before the Civil War of any important sort, name it. You know, I've never heard of one, and you haven't either. And even Rule 22, which is a much later development, when you read it carefully, it doesn't say that it can't be repealed by simple majority rule. It actually says the debate on it can't end until you get to 60. And so here's actually what's called the nuclear option. Republicans used to support it. When they come back, now some Democrats are pushing it. and when the Republicans come back in power, in the Senate, they may push it again. It's also called the constitutional option. And what it says is, by simple majority vote, if the majority is very determined, it basically can get rid, it can end debate on filibuster reform after everyone has been heard. You have to let everyone sort of say their piece. But after everyone has genuinely been heard, a simple majority of the Senate can get rid of Rule 22 because the Constitution itself guarantees their right to do so. And Rule 22, in fact, carefully read, doesn't purport to say otherwise. That's the so-called nuclear option or constitutional option. And it shows the great power of the framework we've been developing here by paying attention to the tools and techniques of America's implicit constitution and America's enacted constitution and America's doctrinal constitution. We can actually, and paying attention to actual institutional practice, we come up with a very arresting conclusion, very significant, that any day, not just the first day of the Senate. The Senate is a continuing body. Every day is the same as any other day. The House of Representatives comes to life, springs to life, a new one every 2 years. It's not a continuing body, but the Senate is. Every day is like the day before. And they can follow the rules that they've inherited from the day before, but every day by simple majority vote, if they are determined, any day, they can change those rules. Now, they should do so only deliberately and letting people actually speak out if they have an objection. But once everyone has been heard, we vote. Minorities get to speak, and majorities get to vote and rule. That's the basic thought. So stay tuned. You're going to hear more about filibuster reform in the years ahead. I'm going to conclude now with 4 case studies that illustrate this general proposition. Here's the general proposition. Where the Constitution is clear, various innovations that run counter to it basically don't survive in the long run. They fail. You know, there are all sorts of interesting ideas that people have, and sometimes they're good and sometimes they're bad. If these innovations and ideas basically fit within the broad contours of the text, if the text can be read to accommodate them, these new adaptations survive. But if they go beyond, if they break the text, they basically actually fail in the long run. So in the long run, actually, America's written and unwritten Constitution fit together. I'll give you 4 examples of kind of new ideas, 2 of which basically weren't in sync with the Constitution and failed, 2 of which were clever adaptations that could be read to align with the written Constitution, and they succeeded. So here's one failure. It's called the legislative veto. And here's how it worked. Congress would pass a law at time T1, and the law might say something like, you know, if you do A, B, and C, you get some special benefit, X, some tax credit or something. Unless one House of Congress decides otherwise later on at time T2, and then you don't get X. So if either House of Congress or both Houses of Congress acting together or something, but without the president's signature, or some committee later vetoes the benefit, you don't get the benefit. That's called a legislative veto. And it was in a whole bunch of statutes, beginning in the 20th century, and when that issue reached the Supreme Court laughed it out of court. And rightly so, because it's kind of constitutionally preposterous. Even the label, legislative veto. No, the veto is for the presidency, and the legislature is supposed to legislate, but they're not supposed to do so with a thing called a veto. 2 simple logical proofs. What are you doing at time T2 when you purport to veto this thing? Either you're saying, well, actually, this person didn't really meet criteria A, B, and C, so he's not eligible for benefit X. If that's what you're doing, that's not legislating, that's adjudicating and judging. That's determining whether factual conditions A, B, and C actually exist. That's for the executive to do in the first instance, and if someone's dissatisfied, for a judge to decide afterwards. That's applying your earlier law to the facts. If you're saying, well, this person doesn't deserve X because they don't really qualify for the earlier standard, A, B, and C that we laid down, not your call, legislature. That's up to executives in the first instance and judges who apply law to facts. Okay? Alternatively, you could say, oh, that's not what we're doing. We just decided that A, B, and C shouldn't be the standard. It should be D, E, and F. Fine, then pass a new law. But that law would require bicameralism and presentment to the presidency. So the two formal proofs. First, if what you're doing in this legislative veto is actually deciding that the person wasn't eligible, that's not legislation, and you can't do it. That's adjudication, and outside a few special exceptions like impeachment, judging the qualifications of your own members, you in Congress are not supposed to be judges. You're supposed to be lawmakers. Alternatively, you're saying the person didn't really, we want to change the standards, and if you're trying to change the standards, pass a new law. Put differently, that's one proof. Here's a different proof. But either way, it's unconstitutional. Here's a different proof. What is the legislative veto? It's got to be either executive, legislative, or judicial. Those are the only three powers in the Constitution. And the 10th Amendment says there are no other powers. If it's legislative, it requires both houses, bicameralism, and presentment to the president. The president gets to veto it or not. So if it's legislative, you're not doing it the right way. If it's executive or judicial, generally you in Congress don't have that power, outside impeachment and these few other exceptions. So when it reached the court laughed it out of court, the Supreme Court did. Presidents throughout the 20th century, every single one of them basically said that legislative veto is unconstitutional. It doesn't go back to the George Washington era, to the founding era. So this was an adaptation, an innovation, an invention, and it failed because it really doesn't fit the Constitution's basic separation of power structure. How about the independent counsels, Ken Starr and others that we had post-Watergate? Well, we need to deal with executive law breaking, but the independent counsel model didn't quite work because judges were picking prosecutors, and that's just not how our system is designed to operate. And how could the independent counsel be genuinely independent and also inferior? Because judges can only appoint inferior officers. Inferior basically meant inferior to judges, magistrates, bailiffs, court clerks. It didn't mean picking people who can prosecute or investigate the president himself. So the independent counsel statute was well-intentioned, but it really didn't fit the basic constitutional structure. It gave improper non-judicial powers to judges. It created someone who was supposed to be simultaneously independent and inferior, which is a weird thing. Just like legislative veto is a contradiction in terms, inferior and independent, that's a weird combination. And the system basically failed, and it failed because presidents came to recognize that this system was a constitutional monstrosity, and they refused to reauthorize it. The legislative veto statute was just a temporary experiment. It lapsed every few years, and after a certain point, presidents said, we're not going to support this. And these were Republican presidents as well as Democrat presidents who eventually came to that position. Bill Clinton alongside George H.W. Bush, for example. Just as presidents of all stripes, Republican and Democrat, had come to see the legislative veto as unconstitutional. So those things went beyond the text of the Constitution, and they failed. I'll give you two clever innovations, adaptations that are within the text of the Constitution and have survived. One's this really weird thing. It's called the Saxby Fix. In a nutshell, here's what the Saxby Fix is. There's a provision in the Constitution that says if you're a senator or a representative, you are not eligible to serve in some executive or judicial position whose salary was increased while you were in the Senate or the House. Okay? So the idea is you can't pump up the salaries of these existing positions and then basically take the inflated salary position. It's kind of an anti-bribery, anti-corruption idea. You don't want to let the president give you some sinecure, some cushy job to reward you for going along with the president's program elsewhere or something. Okay, but what about these cost of living increases that we have for cabinet officers or something? What if you say, fine, the salary was increased, but I won't take the increase. I'll just take the earlier salary. And that sort of fits the spirit of the provision. I shouldn't be forever ineligible just because we had cost of living increases on my watch. As long as I take the lower salary, haven't I really complied with the spirit of the provision? And a thing called the Saxby Fix is a way of basically taking the position without the salary increase. And it's been done with the blessing of Republican as well as Democrat Congresses and Republican as well as Democrat presidents. It's the provision, it's that little wrinkle under which Hillary Clinton left the Senate and became Secretary of State, because Secretary of State, the salary had actually increased on her watch, but she didn't take the increase. Ken Salazar, that was true of, but it's been true. Republican presidents have also used the Saxby Fix, going all the way back to Ulysses S. Grant and Taft and others. And so that's an adaptation that doesn't really violate the letter and spirit of the Constitution, which have some ambiguities in them. I'll give you one final example. Independent agencies. Independent agencies are basically picked by the president, the members of them, but they can't be fired at will, like the head of the Fed or the other members of the Federal Reserve System, for example. That is a deep part of our constitutional system, how the government is actually constituted, but it doesn't run afoul of the rules. Presidents are picking these people. Presidents are the ones who remove them. They don't get to remove them at will, but only for cause. But the Constitution doesn't have elaborate rules on removal. It has rules on appointment, and to repeat, presidents appoint all these people. There have been times when Congress has tried to pass statutes vesting appointment powers in Congress itself, and the Supreme Court has laughed those laws out of court because that does violate the written Constitution. For the House or the Senate or some leaders thereof to appoint government officials. But as long as the president's doing the appointing and the president's doing the firing, whether the firing is for cause or more generally at will, the Constitution permits both of these systems. Here's one final way of putting the point. Independent agencies have been around for a very long time. Presidents of all parties have supported them. They didn't support the legislative veto. They didn't support the independent counsel, but they have supported the Saxby Fix and independent agencies. So the basic idea, in a nutshell, and here I'm going to conclude, and then I'll, with one final thought about this fellow over here. Where the written Constitution is ambiguous and these informal adaptations kind of fit, can be read to simply clarify an ambiguity or fill a gap in the Constitution, and where all branches of government have pretty much agreed, and especially where something goes all the way back to the founding, this practice, then it's pretty easy. But when these innovations really are inconsistent with clearly the letter and spirit of the Constitution, and they don't have deep constitutional roots all the way back to the founding, and they haven't been embraced by both parties and all branches of government, then actually they don't survive. America's written and unwritten Constitution fit together to form a single system. America's unwritten Constitution lives in its written Constitution, and its written Constitution lives in its unwritten Constitution. Now, who's this fellow? He's the last recess appointment to the U.S. Supreme Court. President Eisenhower appointed Potter Stewart during a Senate recess to the Supreme Court. And since then, presidents have appointed judges to lower federal courts, but not to the Supreme Court. But Potter Stewart is one of a long line of recess appointees who proves that even for the judiciary, you can have this, and the text is ambiguous on this. And I confess, I wanted to share with you this picture in particular. He was appointed to the court in the late 50s by President Eisenhower, but I want to share this with you because this is a Yale MOOC, a Yale Massive Open Online course. I teach at Yale, and I went to Yale College and Yale Law School, and Potter Stewart went to Yale College and Yale Law School. So it's my little way of just reminding you that this is a Yale MOOC. I hope you've been enjoying it so far. We're not done yet, so stay tuned.